started. Senator, in a prayer.
Pray with me, please. Dear Heavenly Father, we thank you so much for this time and for all the blessings you've given us. Lord God, we thank you for the blessing of civil government. We thank you we can come together and deliberate over the things that are before us. I pray that you give us wisdom, peace, and above all, humility. We will glorify you in all that we do. We pray this in your holy name. Amen.
We're going to go out of order as far as the agenda. We'll start off with SB 138, which I'm the sponsor on that bill, so I'll present that from my seat here. Just a little bit of backstory on the city of Mulberry and it coming into existence on January 1 of this year. What happened starting in 2023, as many of you know, my 4 short years here in the Senate, there was an outcry from the citizens up in the northeast portion of Gwinnett County. Their commissioner had kind of taken a stance on multifamily and some other high-density zonings in the area, and would deny some of those or make motions on, changing those zonings, and then, his motion would fail, and then he would get outvoted, and some of those projects would get approved by commissioners that didn't and don't represent that area. And the citizens got very frustrated and upset by that. They felt like they had a lack of or no representation at the local level. And so they came to Leader F. Stration and I through several meetings asking what could be done. And that's kind of where the birth of cityhood started for the city of Mulberry. And moving forward, we went through the legislature last year. The governor signed the bill, and then the citizens ratified that bill in May of last year and voted overwhelmingly to approve the city's charter. Fast forwarding from that, you've got the city council and the mayor were elected in November. And in between that time, I was a part of the transition team as well. The governor appointed me to that before the city council was elected. And through all that, was a series of lawsuits, some coming from Gwinnett County or Gwinnett County being a part of those lawsuits. Several of those have been defeated. They're on appeal. Apparently, it's, in my opinion, a waste of taxpayer dollars, and also trying to circumvent the will of the voters in that area, which is very disappointing to me by Gwinnett County. And it's to the point where, from some of the local elected officials trying to reach out to Gwinnett County, it seems like Gwinnett County's not recognizing that the city exists and continues to be very adversarial to the city. So I'm having to bring a couple of bills forward at the request of the city to help, shore up the charter, also to make sure that the funds that are due the city are actually funneling through and going to be paid on time, and that, Gwinnett County will adhere to the transition process. And that's why I'm bringing SB 138 and SB 139 before you today, starting off with SB 138. Now, it's got several provisions in the bill. Starting off with the first portion of the bill, it limits this piece of legislation to the city of Mulberry. And then moving on to line number 33 through 41 in the bill, it requires that Gwinnett County continues to provide police services to the city unless notified by the city that they would like to opt out of that. And then moving on to lines 49 through 68, this portion of the bill, basically what this portion does, if the county collects an ad valorem tax for police services within the city, and the cost to the county for those police services, if there's excess to that ad valorem tax, the balance of that money would be due to the city and paid back to the city. The city must use that as supplemental police services which could be a number of things. One that comes to mind would be a city marshal, which you see in many local municipalities. And there's also a formula that calculates that the actual cost of those police services. And moving on from lines 69 through 77, that portion of the bill, it requires Gwinnett County to continue to maintain the roads during the transition process unless the city elects otherwise. This has been some ongoing discussions, I believe, from the local elected officials, as from my understanding, that Gwinnett County's threatened to turn the roads over to the city. So this would just reinstate and reinsure that the county would continue to do their obligations. And then lines 78 through 87, this portion of the bill requires that Gwinnett County maintains dams of a certain size, which would be one particular dam within the city. And then lines 88 through 105, that portion of the bill, if they take over a municipal service at any point during the year, the county would be required to prorate that share of that tax for that year, and that would be owed back to the city. For example, as they take over, doing permitting or zoning issues or stormwater services, then if they start that mid-year, it would be prorated, and that portion of that tax or fee that is collected would be sent back to the city. And if you go on to lines 106 through 126, this portion of the bill, it's for permitting. If the county collected a permit prior to the city taking over permitting, those funds would be reimbursed to the city on the basis of how much action the county had taken on the permit. For example, if the county had not taken any action and collected a fee and done nothing further, they would need to process that application and or process that payment and return that to the city. And the reason for this, this portion of the bill, come January 1, there were several applications that building permits, zoning applications, land disturbance permits, final plats on different types of developments. And Gwinnett County, come January 1, threw their hands up and said, now you've got to go reapply at the city of Mulberry. And they kept those fees and stopped all those services. And what city of Mulberry did, trying to be good stewards to those folks and to those customers, they just requested that those contractors, those developers, those builders, that they would get their permit, bring that to the city. The city would honor that and start them at that point and move forward, which has been, very taxing on the city. And simply what this would do, wherever the county stopped, if there have been, services performed, of course, they get to keep that portion of the money. But this would just make the city whole. And moving on to lines 128 through 139 of the bill. This would simply, it would not reopen the service delivery agreements for the city. For the county, which would actually open it up for all the cities within the county. So there would be no need for any renegotiations in the city of Mulberry. They could choose out of the other cities within Gwinnett, whatever agreement they decide, within the Gwinnett boundaries or any cities that were in Gwinnett. And then lines 140 through 147. This would prohibit the city from needing to reimburse the county for any elections for the first 2 years during the transition period. And this was a request from the city. And this is just a statement from me living in the city of Mulberry. When the vote came up for the city, for early voting, the voting location was outside the city boundaries. If you were closest to that voting location, it was about 10-minute drive. If you're on the other side of the city of Mulberry, it was over 30 minutes. And as many of you know that have driven through Gwinnett, it can be, at certain times of the day, the traffic can be very, very heavy. But, and then on election day, instead of having the folks only having to go to their precinct to vote, the county, they had a separate church that you had to go vote for the city of Mulberry, and then there was whatever your voting precinct was, you had to go and vote for the rest of the candidates up and down the ballot. Yes, sir.
Point of clarification on thing you just said. Are you saying during the referendum to create the city, that if you wanted to vote for the city, you went to a precinct at a church, and then if you wanted to vote for those running for elected office, you went to your normal precinct?
That's correct, yes.
So you had to go to two different places to vote?
Yes, and it was not, there again, this is my opinion, because I witnessed it, but it was not well advertised. The county didn't, in my opinion, of course this is a personal opinion, that didn't do a great job of making it clear on how to do that. But yes, they had to go to a church to vote for the city and vote for the city alone, and then whatever your normal precinct was, you'd have to go vote for the president and down ballot.
All right, thank you.
And moving on from lines 148 to 157, due to multiple lawsuits to the city, then also being sued personally myself as a member of the transition team, and many of these lawsuits being defeated in court or dismissed, and it seems like Gwinnett County just wants to continue to go down that road, in my opinion, wasting taxpayer dollars. This portion of the bill, if Gwinnett County continues to seek litigation, and or in participation of any type of litigation through a third party, if they're unsuccessful, then they would be required to pay the city's attorney's fees. And moving on to lines 158 to 162. This portion of the bill, what it would do is it would punish counties that fail to follow the transition statute, suspending their sovereign immunity for 1 year if a court finds that they have violated the transition law. And then sections 2 and 3 of the bill, they have to pertain to it fixes issues allowing insurance taxes to be collected by the city in the year 2025 rather than 2026 or 2027. And that's kind of the crux of the bill and a bit of the backstory. I know we've got a couple of folks signed up to speak. Any questions or comments from the committee? Senator again.
Thank you. I'm Mike Forrest, and one of the things that I wear two hats, a city hat and a county hat, and try to make sure I'm looking forward on both of them. When you do the immunity and then the court costs and stuff, if for example the city were to have to litigate against the county, or thought they needed to, and they lost, what would happen there? Is your bill silent on that, or is it a reciprocal agreement that, if the county's suing the city or the city's suing the county, I always love the loser pays when you get into litigation. I don't know if that's spelled out in I'm not seeing that in the language.
No, sir. No, it is not spelled out in there. But there's no current lawsuits coming from the city.
Okay.
You know, the city officials, they would love to start working with the county and be recognized as a city and, be good stewards with the county and, have a good partnership.
But there is existing litigation from the county suing the city.
That is correct. It's my understanding there's an appeal.
Okay. Thank you.
Yes, sir, Mr. Chairman, Senator Ginn's question, for that to happen, the court of jurisdiction would have to show that, or the city would have to show that the county violated any duty or obligation, right?
That is correct.
Rising out of his, so they'd have the burden of proof, and if they showed that, then that's where the county would be liable for the attorney's fees. Is that right?
That is correct, Mr. Whip.
Okay, thank you.
Thank you, Mr. Chairman. I do have a question in regards to line 158, really line 159, and it's the discussion on violating any duty or obligation arising from this chapter, the sovereign immunity of such county and the governmental immunity of all local officials of such local governing body is waived. I have a question as that would affect, that qualified immunity would affect, for example, the county police department, the sheriff, those other elected officials within the county. Should the county's qualified immunity be pierced, they would then be liable?
Sure.
I think one thing we can't do is we can't cross the wires between sovereign immunity and qualified immunity. Right. So the sovereign immunity would rest within the county. The qualified immunity is the qualified immunity that each of those carry as long as they follow the policies and procedures laid out in the county and in the conduct in which they do their job.
That's correct. And also, it's referring back to the previous paragraph, stating that it's the county during the county's transition in the city transition period. Any further questions, comments?
Mr. Chairman, Randall Mangum from the 55th. I just happened to come in a little bit late. I apologize for that. But I just heard that it sounds like something's been going on for a minute, but I do represent part of Gwinnett, and I just want to look forward to trying to be of assistance to facilitate the ruffling of the feathers. It sounds like some feathers have been ruffled. So thank you. I look forward to just knowing and seeing how we can be of assistance. Thank you. And I'm
Thank
looking
you.
forward to whomever. But since I represent Gwinnett, I want you to know I'm new and I don't know anything. So let everybody know that. I don't know. And I'm responsible, but I don't know.
You're impartial. You're impartial. And for the sake of time, I did allude to the backstory at the beginning of it, but I'd be glad to fill you in step by step if you like.
Let it be known.
Senator Mallow.
Yes, sir, Mr. Chairman. I just, to what the gentleman from the 29th discussed earlier, I just would like to get an interpretation of the sovereign immunity that the county would lose, because I think that's if you act in your official capacity as it relates to doing your job. I just want to make sure that I understand that. I'm not a county elected official, but I would like some interpretation on that sovereign immunity, because to lose that would then mean you'd be open up to just about anything.
I'm going to put you on the hot seat, Paul, if you've got an opinion.
So, Chairman, as I understand the question, it's about the effects of this provision on sovereign immunity. And I will start by saying I didn't draft this bill, and so I'm not as familiar with it as I would be if I had drafted it. But just sitting here and going through it as you were reviewing the bill, my understanding is that lines 158 to 162 are very limited in scope, that they only apply during the transition period and only if the county has violated the provisions above that. And my thought would be that as to any individual officer, that any liability they have would have to stem from an involvement in the county not doing what it's supposed to do. So that's my understanding, just sitting here looking through that.
Thank you.
And just to be clear, because I proudly did not go to law school, chose the police academy instead. That was, yeah, just hurt more. So if the sovereign immunity, by lifting that sovereign immunity, those individuals that intentionally did whatever to make sure the process did not conduct as it should have, they and the county itself could be held civilly liable. Is that right?
I believe that's correct.
Okay, just want to make sure. Yes, sir.
Reading this hold, I believe that's
Yes, sir. Thank you.
Any further questions, comments from the committee? We've got 2 individuals signed up to speak. Got Mike Ludsack. Thank you. And then Todd Edwards is on deck.
Good afternoon, Mr. Chairman and members of the committee. My name is Mike Ludwizak, and I'm the county attorney for Gwinnett County. And I want to thank you for allowing me to comment today on Senate Bill 138. I find myself in the uncomfortable position of presenting, thank you. I find myself in the uncomfortable position of presenting the county's practical and legal concerns with the chairman's bill. But having stated these concerns, I also think that these concerns, and I'll say this again at the end, I think these concerns can all be addressed by an intergovernmental agreement between the parties. And we're certainly open to that possibility. But having said that, the first and primary concern, which I think the committee has already identified, are the provisions which waive governmental and sovereign immunity. Specifically, as a remedy for noncompliance with this bill, it waives the governmental immunity of all county officers and employees in all matters, not just matters related to this, for a period of 1 year. This waiver contradicts the immunity provisions of our Constitution, which provides that all county officers and employees have immunity from suit in the performance or non-performance of their official functions. Most importantly, our Constitution says, quote, "These provisions shall not be waived." More practically speaking, all law enforcement agencies have faced challenges recruiting and retaining certified and sworn officers. This waiver of governmental immunity would have a devastating effect on recruiting and retention, removing all legal protection for these sworn officers. Officers who risk their lives protecting others and thus making all of us feel less safe. The bill also waives the sovereign immunity of the county, which is what you've referred to in certain instances. This is a measure that could expose the county to unlimited liability and operate as a de facto tax increase on our residents, including those who live within the city. Sovereign immunity doesn't protect the county, it protects the county's taxpayers. And ultimately, it could be these taxpayers who are punished by this bill. There are also provisions requiring the county to pay over police special district taxes to the city if the amount collected within the city exceeds the cost of patrolling and responding to dispatches or calls, or investigating matters, crimes within the city. These provisions violate the Special Districts Clause of the Constitution, which requires that taxes collected within a special service district be used to provide solely the cost of providing services within the district. In this instance, these taxes are levied for the purposes of providing police services. However, if any portion of these taxes is required to be paid over to the city, they cannot be used by the city for this purpose, simply because the city does not provide police services. And if the city were to misappropriate these taxes to be used for some other purpose, this would violate the Constitution. This provision also violates the Uniformity Clause of the Constitution, which prohibits special service districts where some taxpayers pay a lower millage rate for the same service, which is precisely what would happen here, and here's why. The provision fails to consider all of the other costs associated with providing police services. Costs like administrative overhead, insurance, training, and capital infrastructure. The county taxpayers in the rest of the special district would be required to be taxed at a higher rate to cover these additional costs for the citizens of Mulberry. Again, this would be in violation of the Uniformity Clause. The bill would also require the county to maintain certain stormwater infrastructure within the city. And this is even after the city takes over the provision of stormwater services. This arrangement, forcing the county to pay for stormwater infrastructure within the city without an intergovernmental agreement and without receiving any consideration in return, also violates the Gratuities Clause. The stormwater utility fee paid by county residents cannot and should not be used to pay for stormwater infrastructure within a city that charges for and provides its own stormwater services. Now again, having stated all these concerns, I don't think there are any that could not be addressed and resolved to the satisfaction of the parties by way of an intergovernmental agreement. And frankly, I think that would be in the best interests of all of our citizens. So on behalf of myself and the Gwinnett County Board of Commissioners, I want to thank you again for allowing me to speak today.
Thank you. I don't want to butcher your last name. Would you say that again?
Ludwizak.
Ludwizak. I got half of it
Yes.
right, so I don't want to mess that up. That's it's valuable to all of us, Mr. Ludwizak. You know, I always appreciate the appreciation of law enforcement and everything and amazingly, it always becomes part of the conversation for some reason when people like things or dislike things. But help me understand. I understand qualified immunity, and if an officer loses their qualified immunity, I understand exactly how they've opened themselves up to that. Help me understand how the county losing their sovereign immunity affects the individual officer in the performance of his or her duty where they would sacrifice their qualified immunity.
Right, so there's two particular provisions in this bill, which if a court of competent jurisdiction finds that the county or a county as currently composed, this bill would only apply to Gwinnett County. But let's just say a county fails to comply with the provisions of this entire chapter, and a court of competent jurisdiction finds that to be the case, then there's actually a penalty imposed against the county. And that is it loses its sovereign immunity in all matters for a period of 1 year. So that goes to the county. It also provides that governmental immunity, in other words, immunity that would protect officials and officers and employees of the county, would also be waived for a period of 1 year in all matters, exposing them to individual liability. And that is of course, and I think the committee identified that concern, that is of course of great concern to us with this bill and the impact that losing that immunity might have on our recruiting and retention efforts.
Okay, so it would be the appearance or losing of the sovereign immunity you think would impact the ability to recruit and bring in good officers and have a good, safe community?
Correct, sir. Not so much the sovereign immunity,
Right.
but the governmental immunity that would protect those officers in their individual capacity.
Okay, we're talking about immunity granted under the U.S. Constitution when we start talking about qualified immunity, right? Okay, so I'm a little confused on how the infighting and the losing of sovereign immunity and governmental immunity on a state county would impact a constitutional immunity given under the United States Constitution. And I know you referenced the Constitution several times, and my assumption is you're referencing the Georgia Constitution, correct? And you're referencing the section where basically it lists what qualifies an area to be a city or county, certain services that have to be required and all of this. You have to hit certain marks to do that. So I would appreciate it, and offline or whatever, if you can give me the places in the Georgia Constitution that you feel are being violated by this particular piece of legislation, so I could, and not today, I mean, just when we get an opportunity to do that. And you referenced that you think this problem could be solved by intergovernmental agreement, right?
I think many of the issues of providing services, these are, as it stands right now, these are residents of both Gwinnett County and Mulberry.
Right. And since the city of Mulberry came into being, what effort has been made by the county to enter into an intergovernmental agreement with the city of Mulberry?
Yes, sir. I've had several conversations with Attorney Bill Riley, who represents the city of Mulberry, the mayor of the city of Mulberry. In correspondence, I don't know if that was directed to me, but that may have been directed to our chairwoman, had indicated that a draft intergovernmental agreement was forthcoming.
Okay.
And then my subsequent conversations with Mr. Riley also indicated that a draft intergovernmental agreement was forthcoming. And then I know from looking at the minutes of meetings from the city of Mulberry that he indicated to the city council that he would be providing them with a draft intergovernmental agreement.
Okay, and final, Mr. Chair, if I may, during the process of creating the city of Mulberry, there was a referendum.
Correct.
And citizens impacted were required to go to one voting precinct and vote on the city of Mulberry, and then required to go to their normal precinct. Can you help me understand why a citizen would be required to go to two precincts to vote?
Yes, sir.
Just help me.
And I had not heard that, and I do not know the reason for that, but I can certainly find that out.
But you are the county attorney, right?
Correct.
So you would have been a guy that you hope they would have the intelligence enough to run it by, because you are the keeper of the law and try to keep the county out of trouble, right?
My thought is that would not have been a legal consideration as much as a practical consideration of where an election.
So voters' rights wouldn't have come into the conversation, you don't think?
I don't have the
Yeah.
information on that to tell you.
Okay.
I don't know.
I do appreciate that, thank you.
Any further comments from the committee? Seeing none. Thank you, Mr. Whip, for those questions. That was one of mine, but I appreciate you getting those answered. The other, make a comment on PD services, police services. If there is surplus ad valorem taxes that are collected that would go to the city of Mulberry, it would have to be used on supplemental police services, so it would have to be used for police services within the city. If that is collected, it couldn't be used for general budget items or anything of that nature. And as far as the stormwater comments the attorney made, that just refers to one dam on a lake within the city. It's not complete services of stormwater runoff. Any further comments or questions? Thank you very much.
Thank you, Mr.
I
Chairman.
just wanna make sure I get your card.
Yes, sir.
Got Todd Edwards.
Thank you, Mr. Chairman, members of the committee. I'm Todd Edwards with the Association County Commissioners of Georgia. I want to be clear that ACCG has not ever or intends to take positions on individual cities being created. We see that usually as a local act, even if it goes through general bill impacting that community. What we have concerns with in this bill, and I will admit, the way this bill is drafted applies only to Gwinnett and currently the city of Mulberry, which was recently created, as you stated earlier. But the precedent that it might set for new cities being created going forward. I'll focus on a couple of key areas. Service delivery, tax equity, and uniformity. A lot of the uniformity was discussed earlier. First gets in, and I'll just go to the page 3 on law enforcement cost and how that's going to be measured. It talks terms in actual cost. How do you measure that? Through actual time, the county police department enforces or provides service in that area, measured by patrolling and responding to dispatches. I think that's going to be incredibly hard to measure for each police officer, and it doesn't take into account indirect cost or other costs that are much broader than the actual patrolling, dispatching, and investigating crimes. The city and several cities that are created, if they have issues with the county police force, and I will remind you that counties are not required to provide police services in the state. I think there's 12 or 13 that do. Most of the counties, law enforcement outside the incorporated areas is taken care of by the sheriff. So counties not at all required to do this. This requires them to do that, and then it gets into measuring services, comparing costs, which are going to be hard and do not take into account the indirect cost or other costs outside patrolling and dispatches. Second, the city, it states in here, controls the right-of-way. That's the road right-of-way where a lot of utilities are located, and the city will still collect franchise fees for controlling that right-of-way. That's very clear in this legislation, and traditionally franchise fees go to local governments, county and the unincorporated area, city and the incorporated area, to pay for the management of that right-of-way. What this bill allows is for the city to collect those fees, yet the county taxpayers, remember this is about taxpayers, all the other county taxpayers within the county and also within the city too, they pay their county taxes, would be actually funding that right-of-way. So cities could make decisions in that right-of-way, controlling growth, development, traffic, utilities, but it would be dependent on the other county taxpayers to fund those, even though the funding is not collected, the franchise fees by the county anymore, it's collected by the city residents. So it's an example, and I hate to say it, but of having their cake and eating it too, which goes on to stormwater fees as well. When the city of Mulberry was created, it chose to provide 3 services: planning and zoning, building codes, and then stormwater fees, or stormwater utility. Stormwater fees used to be collected by the county. Once the city is incorporated, the county no longer collects those fees. The county utilized these fees to maintain stormwater infrastructure, including dams, and I know this is limited or in that particular area. But now the city collects those fees, but under this legislation, county taxpayers, countywide, still have to pay for those stormwater services within the municipal district. That is concerning. We believe it sets a very dangerous precedent. Again, stormwater fees, they're legal, they're collected by the entity, and county can no longer collect them within the city, but still has to provide the services under this legislation. The last one I'll mention about is traditionally, and there are admittedly, and we've tried to work on this, very few conditions on creating a city in the state of Georgia. But what has traditionally happened is with the city, when they are created, there's a referendum, not required by law, but this is what's traditionally been the case. The referendum is paid by county taxpayers at large, with the condition in all these local acts or these general legislation creating new cities stating that if the city is to be successful, then the city is to reimburse the county taxpayers, again, taxpayers of the entire county, for the cost of those elections. This bill states that that is no longer the case here in the creation of Mulberry. I'm sorry that there are lawsuits. I do believe that a lot of this could be taken care of through service delivery, through intergovernmental agreements. It's unfortunate. I hope both parties can find a way to work together We mentioned intergovernmental agreements on some of these services. That was asked about earlier. Traditionally, and what we've done since 1997 is had these agreements through what we call the Service Delivery Strategy Act. Cities and counties get together, talk about which services are provided by whom, and more importantly, who pays for those services. As we know, many of you at this table, they can be contentious, but it is that mechanism by forcing that intergovernmental agreement, or the cities and counties get their state funding cut off, which is a very strong stick. The creation of new cities does trigger service delivery renegotiations under current state law. If I understand this bill correctly, this does not allow them under here. Should it, then some of those intergovernmental agreements may be worked out. I thank you for your time and consideration. I'm not a lawyer, so I can't go into the immunity practices, but Mike did point out the difference is this both applies to sovereign immunity, the accountability of the county, and official immunity, which does impact individual officials, which my understanding is protected by the Georgia State Constitution, that they cannot be sued in their official capacity. But again, I think that was discussed earlier. I'm not an attorney, but did want to point that out. Thank you for your time and consideration.
Senator Mallow?
Thank you, Mr. Chairman. I just have a question, and I don't know if you all know this, but does Gwinnett County collect the local option sales tax?
May I refer?
Mr. Chairman, I yield to the gentleman from the 47th, but I think we can solve all the money problems if y'all just put a local option sales tax on the ballot, and then you'd have it all worked out.
We should have had you get involved in this last year. I mean, geez. Thank you for your comment. Mr. Whip?
I do have a lot of respect for my friend from the other party because we can solve it just by adding taxes. We can do it. I've got one in Muskogee County that we helped put in there. Yeah. Mr. Edwards, my friend.
Yes, sir.
We keep talking about how difficult it is to price out police services, but you know there's a few organizations out there. There's the International Association of Chiefs of Police that just chomp at the bit to come into law enforcement agencies and help price things out. Police service is no different than any other kind of service. There's margins built in. There's actual costs of bricks and mortar. There's costs of operating vehicles. There's costs of maintenance with everything. There's equipment costs. There's salary costs. There's health benefit costs. I'm just just a deputy sheriff from Harris County, but I can tell you it's pretty simple to break down the cost of any service within a government. I worked for the Consolidated Government of Columbus for about 30 years, and I promise you, once I got into the position to have to sit there and crunch numbers and determine what percentage of every employee I had carried out a certain task each day and what that task cost, it's really not that complicated. And so I would think that when we have a county as wealthy and prosperous as Gwinnett, that they would be able to figure out how to do that without a lot of trouble. And I know the ACCG is their go-to organization, to basically their membership organization, to help them do this. And so I'm sure you guys could help with that. But I know we talk about the franchise fees and everything, and I'm going to let you help educate me a little bit. The franchise fees here in the city of Atlanta, who collects those?
Sir, may I first address your
Sure. Yeah,
initial
if
comments?
you want
So
to. Yeah.
break them down as you may, know how much cost there may be involved. My understanding of this bill is those costs can only be calculated on, and point well taken, by the way, but here only patrolling, dispatching, investigating crimes. So the other stuff you got into indirect cost, et cetera, but whatever they are.
Right.
I did address it, but you did as well,
Right.
but not taking it into account here, they have to be reimbursed.
Yeah,
the city
but that's what I'm
does,
saying, though.
yes.
Once you get that cost, you know what the reimbursements are.
Well, but you can only use those that can be documented for patrolling, dispatching, and investigating.
And dispatch.
The taxpayers from the rest of the county pick up the rest.
Yeah, I understand.
Okay.
But, well, they pick up the cost for the sheriff's office, right? That patrols the entire county, to include City of Mulberry if they choose.
Well, yes.
Yeah. So
Yes.
what I'm saying is those costs are not difficult to find. They're not difficult to figure out what the reimbursement should be. These aren't costs that cannot be measured. the cost of, the cost of services provided can be measured. And so
But
I
it
think,
can't be charged under these, only for these three conditions.
Well-
And perhaps I'm not understanding, and I
yeah,
apologize.
maybe I'm misunderstanding too. I'm just, it seemed like to me there was some confusion over, they're asking for reimbursement or something, but how do we know what that cost is?
Okay.
And how can we reimburse not knowing what that cost is? And the second piece on the franchise fees, just help me understand, who collects franchise fees here in the city of Atlanta?
City of Atlanta, sir.
Okay, so Fulton County gets no reimbursement for that?
If there were in an incorporated area, now that might be, well, it wouldn't be Atlanta, so no, the
Right.
county would not collect them.
Okay, so, but all taxpayers of Fulton County pay that tax and all citizens of Atlanta pay that tax, right? Or
Well, okay,
benefit
now
or-
that gets a little tricky.
Yeah,
So let's just say there's utilities, I guess, they can be charged on gas, cable, telephone, electric. So the customers of those utilities usually pay that tax. It's a pass-through. City gets the money, customers get it. It's broken up different ways. If like Georgia Power might, if it's unincorporated, we'll still pay some of that. That's a different story, but
Right.
it's usually a pass-through. There's variances, but the city residents and sometimes county residents to pay through their bills for the city to collect those franchises.
thank you, Todd, I appreciate that.
Yes, sir.
Any further comments or questions? Senator again.
Thank you, Mr. Chairman. I can see this bill going a lot of different places, and it's kind of they used to talk about in science, a catalyst. Said sometimes you throw a little catalyst in to make something happen. I'm looking at the bill, and that might be the catalyst to get the parties to get that intergovernmental agreement going. I'm not sure exactly where this catalyst needs to go, but I do think there's some discussion that needs to take place more so between the city and the county, and I don't look at the bill as perfect. See, and I was curious. I don't want to. It's your bill. You're the chairman. Said if we sat on this till our next meeting, you think we could encourage our catalyst that with the overhanging, don't want to do that. Okay.
No,
Because I know that right now it's out there, and I think you can make something happen with just giving them a week to come up with that intergovernmental agreement.
Yeah, Senator, I do respect your comment, and I understand, where you're coming from with that. But the county ultimately refuses to recognize the city's existence until these lawsuits are done. So you're talking if they continue to appeal and waste all of Gwinnett County's taxpayers' money, we're talking about months and months and months. They want to, in my opinion, they want to starve the city out of existence. The will of the voters they've already spoken. This will give them the ability to start pushing and get the city off the ground, because the county is obviously not working in good faith. And talking about sovereign immunity, as long as they go along with the transition process and don't continue to try to snuff out the city, there's no issue. And we've come to this. I know y'all have not been in this fight, and I'm passionate about it because I've called Gwinnett County home my entire 45 years, and I love Gwinnett County to my bones. I've told people many, many times that, I hope I'm raising my kids there now, and I hope I live there my entire life. But to see what's happening in this area and the lack of representation they had, and we created the city in good faith. The citizens voted on this, and the county wants to continue to push down this road to snuff the city out is just irresponsible with taxpayers' money, taxpayers' time. Like I said, I was even sued personally as part of the transition team. They've tried this in every way. Stopping and giving them a week. You're talking about David and Goliath here. When you're talking about, the city or the county attorney talking about, oh, this is going to increase taxes for the entire county, I don't believe that. You're talking about a $2.67 billion budget for 2025 for Gwinnett County. In the when we had the study done for the city as far as the calculation of revenue that would come in, it was just over $9 million. To talk about these services in this small area to a county that's that large, You know, there's not a big loss to Gwinnett County here that some of these services is gonna now be a tax burden on, you know, all of a million, you know, residents in Gwinnett County. I just think that's completely false. And we have put good faith forward. You know, it's my understanding that city council members and the mayor have reached out to the chairman and other commissioners, and they've been advised not to talk to them. So they can say, oh yeah, we're working on, yeah, the city can work on an intergovernmental agreement, but the county's just gonna continue to starve them out with all these frivolous lawsuits, in my opinion. So I think this is the heavy hand we need to move forward. Unfortunately, we've come to this, and I hope I can get your support, but we do need to continue to move this bill, if the committee sees it fit.
Mr. Chairman,
Yeah.
I would like for you to move your bill forward, but I want to join my distinguished colleague, Senator Ginn, only to give an opportunity. I have a dinner planned tonight with Gwinnett County, and I just really want an opportunity to just put 5 cents in it and tell them I'm going to help them get real uncomfortable if something doesn't happen. So I think that I hadn't been a part of it, and I know you've been it for a moment and you're very passionate about it. But I would also like, I think we got a little time, if you just give us a little time, whatever amount of time that is, at least I'd like a little time to communicate with some people the seriousness of this matter.
No, and I do respect you, Senator. I know you're new to representing Gwinnett County, and this has been an ongoing issue, and I'll continue to fill you in. But unfortunately, you know, not unfortunately, but the legislative process is a long process. You know, we've got more vetting and rules. We've got, you know, we've got to present this on the floor of the Senate, and of course, it's got to go through the vetting process in the House. And you know, I'm not wanting to slow this process down. I think that we need to continue to move forward. And I know you've not been in the trenches, you know, of this issue like I have for a year and a half. But there again, like I said, the county has had plenty of time to recognize the city and start working with the city. The city council, you know, has tried to extend that olive branch, and it's just not happening, unfortunately.
Mr. Chairman, I have a lot of respect for our new senator, and I have a tremendous amount of respect for Senator Ginn and his experience in the counties and in the cities. But having been involved in an attempt to create a city before, I think everything that gets lost in the conversation is the fact that the citizens have chosen to have the city of Mulberry. They went out and voted, even though, shockingly, to myself and to the county attorney who was not aware, they were asked to go to one place to vote and then get in their car and drive to another place to vote. That being somebody who is still being sued under SB 202 because of voter rights, I think it's important that we do not lose sight of the fact that that just seemed like a big impairment or an attempt to keep the citizens from going out and speaking for what they thought was best. And I do agree with the chairman that if there was going to be an intergovernmental agreement, you're represented by groups like ACCG and others that are absolute experts at sitting at the table and bringing things together and getting people to partner up. And if it's taken this long, and it's amazing to me how many times we have to do something in this building for people to start showing up and saying, you know, we were just about to do that. And, well, if they were just about to do it, we're not going to impede them from doing it. But at the proper time, I would make a motion to pass.
I'll recognize that motion. Do I have a second? I have a motion and a second. Do pass on Senate Bill 138, LC number 473385S. Any discussion?
Absolutely, Mr. Chairman. Mr. Chairman, the only thing that gives me heartburn, I'd be happy to join and vote this out of committee, is the waiver of sovereign immunity and governmental immunity in all matters arising during this one-year period. In the General Assembly, I have learned that shall means shall, must means must, and as nearly as possible means when the heck you can. And so where I see that is waived in all matters, that does give me trepidation, because while it intends, in my opinion, to pertain to what's up. It is when it says and waived in all matters for 1 year. And I just think that would be something to consider, that it would be waived in all matters. And that's my discussion. The motion is on the table at the time. And so hopefully my no vote is reflective of my concern on the immunity.
Thank you, my friend.
Mr. Chairman, I have that similar concern. Maybe it can be worked out afterwards. That just, when you say all, that can have really unforeseen consequences, because I'm a lawyer and people can take advantage of things, and even though you wanna, spank them, you might do a little more than spank them. That's all I wanna say.
No, I respect your comments. Thank you.
Thank
Thank you for that. And I understand, your position, but, and it does, this is a very heavy-handed measure, but unfortunately, it's been a long time coming. And, as the city or the county attorney mentioned that they are open to discussions, dealing with, as far as services and things of that nature, and recognize the city, this process through the legislature and getting it signed by the governor does not happen overnight. So, maybe, if the committee sees will that we continue to move this bill, maybe some discussions will start with the county, and we'll see what happens with the bill after that. But thank you again. Any further comments or questions? With that, I've got a motion. I do pass. I've got a second. All in favor, raise your hand. Those opposed? Passes 5-2.
Thank you.
Thank you. Moving on to SB 139. This also pertains to the city of Mulberry, working off of LC 473389S. And the city, they've requested several parcels to be annexed into the city. This comes at a request of the city, and it's several large vacant parcels and some commercial areas. I do have a map I could pass around. I could tell my friend from Savannah was looking for some maps. I'll pass that to you. Any other committee members want to see the map? I'm left-handed.
Mr. Chairman, that's looked like a puzzle to myself, and I'm sure someone will speak up if there's any issues.
No, they're not. What I'm going to do is, I'm going to back up and we'll hear Senator Setzler's bill. I was hoping to get this and it was late arriving, but it is a map that's contiguous so you can see it with the background of going at it, so it's more clear. So we'll go ahead and hear his bill and then come back to it if that's okay.
And I'm
Just for
happy to
clarity.
do that, Mr. Chairman. And as my friend across the way, he has dinner with Gwinnett County tonight, and I know that's important to him. But I have dinner with my wife, and it's a heck of a lot more important to me. So if we get moving, I'm ready.
I have a chamber meeting. My home county chamber is meeting at 5.
All right, well, we will move this along quickly then. Everybody's hungry.
Well, I just gotta get back down I-16.
Yeah, you got a long ways to go. All right, so we'll back up. We will, again, go out of order and hear SB 51, Senator Setzler. However you prefer.
Thank you, Mr. Chairman, members of committee. Bring before you today Senate Bill 51. Senate Bill 51 is a bill relating to the quality-based selection of architects and engineers and surveyors. Before I present this, and I know there's some sensitivity to time, but in the world of construction and public works, architects and engineers are the trusted advisor. Just like in the court system, if you were going to go to court and have a property dispute, or you're going to go to court and defend your liberty in a criminal case, the attorney is your trusted advisor who is an expert, not just in the law in general, but in that specific area of the law in which your dispute is the case. Same thing for architects and engineers. There's a very broad field. There's great specificity and expertise. You know, there are civil engineers that do wastewater treatment. There's civil engineers who do roads. There's civil engineers who do site work. Architects that do all kinds of buildings, historic buildings, traditional buildings. The architect engineer is this trusted advisor that when an owner is engaging in a project, a public works project over $1 million in size and scope, just as we would need an attorney in a court proceeding, governments and entities need architects and engineers as their trusted advisor. What Senate Bill 51 does is it would recognize that just as the law requires at the federal level, just as the law requires for entities at the state level, and just as the law requires of local governments in 10 of the 13 states around us, is that for hiring and engaging an architect or engineer for projects over $1 million in scale, the quality-based selection process is followed, in which essentially a decision is made of who the architect and engineer is going to be based on their qualifications and their expertise. Once they're selected, then you enter into a second phase, which is discussion of fees and negotiations, so that the fee and the scope matches. The reason this is the case is because cities and counties, particularly small ones, and if there's anything this bill is helpful for, it is for small cities and counties who don't have the staff, don't have the expertise in-house, they don't have big public works departments that have particular expertise. You go to Gwinnett County, go to Cobb County, they've got folks who themselves are professional engineers on staff who can do some of these things and can help sort through this. But particularly for small governments that don't have the expertise, what the QBS process does is it says, you're responsible to do one thing. Make the smart selection of who the expert is that has the expertise. Once they're selected, they then enter the process, and you walk through and you negotiate what a fair fee and scope should be. That's how it's done at the federal level. It has been federal law since the 1930s. It is against the law to procure an architect or engineer by the federal government in any way other than what's called the Brooks Act. You take qualifications, you rank order best, second best, third best, all the way down, and then the government engages in exclusive negotiations with the most qualified. The Board of Regents, by law, does that. The GSFIC for all other state projects, by law, does that. And as I said, in 10 of the 13 states around us, local governments must do that. It's just in Georgia, local governments are not required. And what we're recognizing in this bill is that the funds being spent are the funds of the public. The funds don't belong to the local government. They don't belong to the city council, don't belong to the mayor. They belong to the citizens. And WISE, when you're talking about a larger project over $1 million, it is an industry best practice that trusted advisor be selected based on their qualifications, not based on low fee or based on some mix of characteristics. I'll explain what QBS does, and we can walk through the bill. I don't want to belabor the point, but I do want you to understand the details of exactly how this plays out. In a quality-based selection process, the first thing is that a local government, in this case, should the bill pass, this is what happens by federal agencies, this is what currently happens and has happened by state agencies, is they put a simple request for qualifications out. They said, here's what the project is. It's a pretty straightforward description of the project, and here's the criteria we're looking for in our architect engineer. One thing this bill does, and it's very important to recognize, is this bill would give cities and counties much broader flexibility than state agencies have. This bill says that the evaluation criteria shall be determined at the sole and absolute discretion of the local government. That state agencies, the regents, federal agencies do not have that kind of discretion, but this bill gives them the sole and absolute discretion to decide their criteria as it matches, as it fits their needs, because we recognize we want to give them flexibility to make a wise choice and to tailor it to the many kinds of projects they have. But when that request goes out, firms are given a deadline. They would submit qualifications. Those qualifications are read, and they're rank ordered, most qualified, second most qualified. There's kind of an order of merit list. And once that's established, the government sits down with the most qualified firm and talks through, okay, you're the most qualified firm. We think the fee range is somewhere in here. We think this is the scope. And what happens in practice is this back and forth arrival of what the scope should be and what the fee should be. The reason this is essential, and this is the most important part of this entire proposition is, I'm not picking on small governments, but it is true of smaller governments. The most important part of this process is understanding what needs to happen and how does it need to happen. If I want to have a wastewater treatment plant expansion in my community, I don't know if it should go over there. I don't know if I expand the one I've got. I don't know if I need to buy more property. I don't know if I need to bring in some modular units. The options are infinite. And governments don't have the expertise to even think through those decisions without, again, the trusted advisors. And what this does is you get the architect and engineer selected on quals, and then you talk through how do we proceed. I'm going to talk through a couple examples of my own experience because I work in this industry. In the state context, I do very little work with state agencies and with local governments. In fact, since I got elected to the legislature, I've never pursued a state contract because I don't think it's appropriate for me to do that. But I have worked for local governments, helping them manage this process, helping them hire architects and engineers and builders to kind of coach them through the process, because this process is very, very helpful. And it's the way that when I work with my federal clients, federal agencies, we do all of our work. So I've seen this in person, and I'll share a couple examples of how this works and why I think it's the best way, and I think why we see overwhelmingly this is the standard. When you enter those exclusive negotiations, the understanding of scope is formulated by this trusted advisor, so what they're paying for matches what they're getting. There's a specific example of a project we did in Louisiana a couple of years ago. The client sent us a scope. They said, hey, we want you to do this. They had selected us, and it was going to be about a $55,000 to $60,000 fee to do the work. Okay? It's a simple calculation of how many hours by your people. I looked at it and said, guys, you don't need to spend this kind of money on this. All you need us to do is show up, take some photos, do a site visit, agree on a system, and I can give you drawings and give you a project for $19,000. Don't spend $60,000 to do this. You don't need to do that. I can do this for 18. If you make me follow the scope that you wrote, they did their best to write a scope. They took a template from somewhere, they wrote the scope. This is going to cost you $60,000. I can do this for like 18 or 19,000. They said, well, that's great. We'll mark that up. So we marked it up and said, let's take this out. I'll do a site visit. We'll have a conference call, and then my guys can produce 5 or 6 drawing sheets, and you're done. Put it out to bid. We got under contract. They paid us $18,900. We did the job. It was a huge success. We've done 6 projects with that client in the last 4 years because when we got on board, we didn't do what they asked us to do. We were their trusted advisor. And we said, it's not in your interest to spend $60,000 to hire us to do this. It's in your interest to spend 18 and we'll do a great job for you. That's what the architect and engineer does. Owners themselves don't have the expertise to know even how to proceed on these projects until they have the expert in the room. Any more than you would know how to litigate a civil case without a civil litigator who's expert in the area in which you're litigating. It's the exact same circumstance. So what this QBS bill simply does is it says, local governments, don't worry about all the trouble you go to writing scopes and formulating these ideas of how the project's supposed to proceed. You have one thing you need to think about. Put out a request, get the right experts in the room, make a wise decision about who your trusted advisor is going to be, and then from there follow the same process that the Board of Regents does for $2 million projects or for $100 million projects, or that DOT uses for $40 million projects and $70 million projects and $2 million projects. We're simply saying local governments, it's the taxpayers' money, there's too much at stake to get this wrong. Follow the same process that federal and state agencies use when you're doing procurements over $1 million. Under $1 million, do it your own way. There's no need to do this. But that's what QBS is. And I'll close by, again, Mr. Chairman, by saying, when you think about low bid projects, well, why don't we just give it to the lowest bidder? When we talked about this several years ago, I rolled in a set of drawings. It was for a $40 million roadway up in northeast Georgia. If you can imagine a set of drawings that's 24 by 36 inches in size, there's about 300 sheets stacked this high. It's about a 40-pound load of paper. And there's a stack of specifications in a manual this big. It costs, to get that designed, it costs about $1.5 million to produce that paper. When you spend $1.5 million to produce that paper, you have enough information to give that to a construction contractor and have him hard bid and quote that for a specific amount of money. Why does a stack need to be this thick? You could do it on 3 sheets. But on 3 sheets, you can't tie down the details that are needed to hard bid a project. To hard bid a $40 million project, it takes 200 or 300 sheets to do it. That's why you spend $1.5 million to get that done. A local agency in a 10 or 15 page advertisement cannot tie down the scope in sufficient detail to lock scope in and to hard bid this work. And most importantly, I'll close by this, Mr. Chairman, there's no way we can expect them to have the expertise to know even what the scope should exactly be until they get the trusted advisor in the room. What this bill does is it says local governments should make one simple decision. We're gonna put out an RFQ, request for qualification. We're gonna hire the most qualified consultant as our trusted advisor. And when they're on board, then we'll work out fee and scope. That's what this bill does, Mr. Chairman. Glad to take questions.
Thank you. Any questions, comments from the committee? Seeing none, we've got two folks signed up to speak. The first is Kaylin and Ted from ACCG Fayette County.
Good afternoon.
Sorry, the mic on your left is the only one that works. You all have to share.
No worries. Thank you, Ted. Good afternoon, Chairman and committee members. My name is Kaylin Day with ACCG, and just on a quick personal note, as a former intern and legislative assistant for this committee, it's a very full circle and a full honor to be for my first time testifying in the Senate to be here. It's really wonderful, but I again appreciate this opportunity, although it is to speak in opposition to Senate Bill 51. I'd like to start by saying that ACCG does not take any issue with qualified base selection as a procurement method. It may be a wonderful method, and it is currently being used by counties when they receive federal funding. We have found that this method is used much more often by our larger counties who have the dedicated staff and resources as opposed to our smaller counties who might be in a situation where they're relying on their clerk to do procurement processes. Again, QBS is already a tool that counties can use for procuring professional services at their discretion, and many of them currently use the traditional request for proposal process, which allows them to see the qualifications and the price at the same time. They also use professional service contracts because it works well for them. These methods allow counties the discretion to choose quality firms while assuring their taxpayers that these fees are not out of line with current market conditions. There's simply, with all respect to the sponsor, there simply is just not a compelling argument here to throw out this discretion and make QBS the county's only tool for procuring professional services. This bill would possibly set a strong precedent for other industries and professions to come forward with mandates that might further tie the county's hands. One of the best ways that local governments can determine fair and reasonable fees is to compare the prices offered by those submitting proposals. Senate Bill 51 would forbid local governments from seeing these proposed fees until they have entered negotiations. And this puts counties at a disadvantage when negotiating. They would not have the sufficient information to understand the current market conditions for their area. And this is especially the case for smaller counties that rarely take on projects of such a size. And I do appreciate Senator Setzler for speaking with us on this bill and bringing up the smaller counties. Although we do have a differing perspective here, we feel that this legislation would result in our smaller counties being at a disadvantage when negotiating or spending part of their project budget on hiring a consultant to help them do this process. So at the end of the day, like I know this committee already knows, local governments are responsible for being good stewards of the taxpayer dollars. They are the experts on their budgets and their community needs, and QBS is already a tool that they can utilize. And they should continue to have that right to utilize this tool at their discretion. Ultimately, sometimes a county just does not have the funding to go with the most qualified, most expensive firm out there. Sometimes a well-qualified, perfectly well-qualified, but competitively priced just makes more administrative and financial sense. And so respectfully, I have to ask that this committee vote no on Senate Bill 51. I'd like to turn it over to Ted Burgess, the Chief Procurement Officer for Fayette County, who has a few extra remarks to give.
Thank you for this opportunity. There's a significant difference, as you know, between federal and state level projects and local projects. Differences in size, complexity, quantity, and cost. To illustrate, in fiscal year 2024, the Georgia Department of Transportation issued 1,342 engineering and design contracts for road construction worth a total of $747 million. Their Office of Procurement has 36 positions, of which 13 are dedicated to engineering and design contracts. This enables them to develop the necessary skills and knowledge to properly negotiate a complex QBS agreement. By comparison, in calendar year 24, Fayette County, where I'm from, awarded 9 architectural and engineering contracts or task orders above the $75,000 threshold, with a total value of $1,818,704. The county has a purchasing department of 4 staff to take care of procurement needs for all functions. So as you can see, there's not the same opportunity to develop the in-depth knowledge to adequately negotiate a contract like this. And then some of the smallest counties, as was said, only have one person managing all their purchasing plus other duties, which is a challenge already. A QBS process may well be the better choice for these state-level projects, but some county governments need the flexibility to choose the best solution for their needs. As we've heard, some of the proponents of QBS procurement have characterized the issue as a choice between selection of professional services firms based on either qualifications or a low bid. In reality, it's not an either-or situation. ACCG sent out a survey to all the counties asking what they use for their procurement methods. 65 counties responded. 48% of the responders said that they mostly use the traditional request for proposal or RFP method, in which they evaluate qualifications, proposal, and price. And that 31% negotiated professional services contract, which has been a method recognized by the court since the early 20th century. The traditional RFP requires firms to provide their qualifications, proposals, and estimated price in one submission. This allows local governments to consider all three in making a decision. For example, Fayette County issued an RFP for architectural and engineering services for a new recreation multipurpose facility. We received 14 proposals. Prices ranged from a low of $327,000 to over $1 million. So if that highest price firm had been the one with the best QBS score, the county may have been faced with a decision on, well, do we delay this project, do we abandon it, or what? Okay, and then there's procedural changes in Senate Bill 51 that would impact county operations in a number of ways, such as they create uncertainties. Uncertainty as to the allowability of increasing popular contracting methods, such as contractor-led design-build projects. In these cases, the general contractor hires the design team, so is that allowable? There's uncertainty as to whether the county has an existing working relationship with a firm as provided on line 106 of the bill, since the term isn't defined. And then lastly, uncertainty as to whether traditional single-firm engineer of record contracts are still allowable, since line 102, only specifies multi-party on-demand service contracts. Again, thank you for this opportunity.
Thank you very much. Mr. Whip?
Thank y'all. I appreciate you coming in and testifying. And remind me of your name again, sir?
Ted Burgess.
Mr. Burgess. Mr. Burgess, y'all currently use the traditional RFP process?
That's the method that we most commonly use.
Right. I'm pretty familiar with the process, worked for a large city for a long time. So my question about that, when you look at the traditional RFP process, the quality of the firms applying are part of that, correct?
That is correct, yes.
But also the pricing of the project is in there too.
Correct.
Do you feel there's a danger that those individuals who are responsible for providing our citizens the absolute best value for their tax dollars tend to look at the price way too often?
Okay, the way we do the traditional RFP method is that we have, and when we send out the RFP, we say, okay, 70% of the score when we evaluate these will be on your technical merit, and 30% on your score, and then we have an evaluation team, and they don't get to look at the prices. Once they have finished their work, then the purchasing department opens the prices and puts that 30% with it. And so there's no chance that the prices will impact how the evaluation team scores the proposals.
Well, Mr. Burgess, it sounds like that you guys may be already doing what Senator Setzler's trying to get everybody else to do. Y'all just doing it in a little more disjointed process, don't you think?
Well, so the way I see it, the difference is that with the QBS process, you only have one price that you look at. Period. You can only ask for a price once you have chosen the firm.
My understanding is you would rate the firms and then you would negotiate the price. And if the top ranking firm, you cannot reach an agreement on the cost, then you would drop down to the second.
Yes, sir.
Qualified. Is that right?
That's correct, but you could not, then you have to permanently close out negotiations with that first firm, and you can never go back to them.
Okay. Thank you, Mr. Burgess.
Senator Setzler?
Thank you, Mr. Chairman. Mr. Burgess, thanks for being with us today and for your time we've talked. I took to heart some of the questions. I want to speak to them directly because you raised those in our conversation. I look back at a award. It was a $14 million charter school project that was average public charter school, so it's following state procurement rules, that went through a non-QBS process in 2018. I was part of the process. And I looked at this, and it's specifically the process you're talking about, where there's this mix of qualifications and fee. And what the facts are is even when you list the fee as only being 30%, 30% fee swallows everything else in terms of how it plays out. And what I've got here, I looked at the criteria. There were 4 firms that submitted on this, and their rankings, there was a 54.7 and 48.8. The range of rankings of the four firms that submitted were 6.5 points difference. Okay. When you looked at the cost and you weighted the cost by only 30% and applied that 70-30, the range among the firms wasn't a 6.5% range, it was a 34% range. Even though you have a 30% criteria, even though fee only weighted 30% of the overall criteria, it dramatically expanded the range of difference between the firms. What that means is the cost is skewed in its impact on the overall selection. Even if it's only even if it's only a 30%, it magnifies differences. So essentially, that when you put money on the table, it swallows all the qualification distinctives. That's an important thing to understand. When you put money on the table, everything else is swallowed by the money differences based on how the breakdown of rating higher cost versus lower cost firm, how that plays out in the 30% swallows the other 70%. And I've got the numbers here from how that was awarded. So it's something to understand. It's not just a piece. It really becomes the whole effort. And secondly, the challenge with what you said is, and I just say this respectfully, and I appreciate the discussion, but that the ability to say that we hired somebody, maybe we didn't get the lowest cost firm, but we hired a firm for X amount of dollars, it presupposes the way you've defined the scope before the project is complete. It presupposes your procurement team, which you said yourself is relatively small, can get your mind around the totality of a $10 million project and define every requirement completely so that what the AE firm is pricing is exactly what's needed. And when you don't have the expertise to define the scope and the needs, that's the very poster child of when you shouldn't try it. Mm-hmm. That's the problem. Because once you take that step, you try to have your procurement staff define what the requirements are. You lock this fee in with a firm, whatever that fee is, you're stuck with that fee. If you hire somebody for $550,000, there's no ability to get that to $400,000 or $350,000. You're stuck with it because you awarded it on that fee. It can't go up, can't go down. It's stuck there, and the scope's stuck there. And you, as a procurement official, have an obligation legally. If you contracted them for $550,000 for this scope, you can't approve a less scope, or you're locked in at that. The government's ability to operate and move where it needs to go is taken away when you don't use QBS. You're locking yourself in. And you said yourself, you and smaller governments don't have sophistication to define the scope, so you're locking yourself in a prison of your own design when you do that. QBS gives you all the power to work with the trusted advisor to get your scope and your fee aligned.
Senator again.
Mr. Chairman, I'm not sure if I have a question for our folks here, but I do want to give an analogy for my learned friend over here. I'm a 20-year manager for local government, 2 cities and a county. One of my favorite things to pick on exactly where this legislation would be very helpful is what I call monuments to stupidity. Said I think everybody in here has seen a water tank, said a typical leg tank, steel tank built. Most people don't realize the cost of those tanks. Said and the cost of putting a tank in service that's unnecessary and not needed and becomes a boondoggle for the community. But I've seen that more and more in local community water systems because somebody came to them and said, "Oh, well, you need a water tank. We can help you get a grant to get that water tank. Here's what we can do." And they get a little bit of grant and a little bit of loan, and next thing they know, they've got a water tank. Well, come to find out, they didn't need the water tank after all. That's where, to me, I don't care what kind of engineer you've got, whether the water tank stands up or not, but we put a bunch of money into a rabbit hole that we didn't need. And for me, this is where I want to try to move this legislation faster. I've told the chairman that I've got to move down the road, but I see far too often that we're out there seeing local governments buying that rabbit hole that they can't use, that's no service to them at all. And for me, I think this is one of the things that I can promise you, when that local government sees that rabbit hole, they'll not be using that consultant again. And this is where, for me, they're going to build that relationship, and long term, the taxpayers will be beneficial on this legislation. So, Mr. Chairman, I'm gonna, if you'll let me offer a motion, I'd move do pass LC 473243.
I'll recognize Senator.
Here's somebody else, please.
Hold on one sec. Yeah, I do recognize that motion. Do I have a second? You do. Any discussion?
Mr. Chairman, parliamentary inquiry, real quick. Was there a second person signed up?
They were in favor of it. It was AC Georgia. Yeah, ACC Georgia.
I think just for the record,
AC.
since they know that there's a motion and a second do pass,
Mhm.
I think it would only be proper to ask if they were comfortable not speaking
Because I'm fixing to leave.
Yeah, because Senator has to go.
That'd be fair. But our next,
They seem
that's what I was assuming, but yes, Mr. Whip, that was appropriate. Thank you for that.
everything, but
Absolutely.
posture now noted.
Thank you for your comments.
Thank you to the committee. Appreciate it.
Thank you. All in favor, we've got a motion do pass, we've got a second. All in favor, raise your hand. Any opposed? Passes unanimously.
Thank you, Mr. Chairman.
Thank you.
I'll tell them hello to Chamberlain.
Yeah, yeah. All right, we've got one more piece of legislation. Yeah, oh yeah, it is. Yep.
We got one more piece of legislation.
Yeah, we've got one more. Yes. I've got a little bit clearer map that you can take a look at. It's contiguous as far as the annexation for the city of Mulberry. This is from the request from the city. Like I said, it's some large vacant parcels and some commercial parcels. You know, going through the process of cityhood.
What is the code color code? I mean, what?
So your yellow portions would be the annexation parcels. And like I said earlier, this is coming from the request from the city.
Still have the floor if I leave.
Yes, sir. Yeah, you can exit.
That's probably a good idea, Senator. I don't know your politics well, but I know your politics enough. Yeah.
Have a great long weekend. Thank you. Yes, so the yellow parcels that are indicated on the map would be annexation parcels. The blue is the current city of Mulberry. You see the purple is the town of Brazelton. And then the gray area is unincorporated Gwinnett in the map. That was a great question, Senator. Thank you for that. But this annexation comes a request from the city. Going through the process of cityhood last year, I can say I've had, and even after the city was incorporated, and our legislation was ratified by the voters, I had countless constituents reach out, upset that they were across the street from the city, that they were nearby, but didn't have a say, and they would love to be a part of the city of Mulberry. But yeah, this is very self-explanatory. I'd be happy to answer any questions from the committee. We don't have anyone signed up for this bill. Senator.
Isn't there a process that if someone's property is in the city, they can go and request that it be de-annexed and come out of the city?
There is a process. If you're in unincorporated, you could request the city to annex you. Yes. As far as de-annexation, I don't want to misspeak. I'll lean on the wisdom of our whip over there. I think he might have the answer for us.
As the sponsor of the Buckhead City Bill,
I wasn't going to say it.
let me tell you, de-annexation should happen because the citizens should have a right to vote. But in the state of Georgia, it's much more difficult. Annexing in is much clearer than de-annexation. And so, but there are processes for both. The problem with the de-annexation are the things we've been discussing earlier, the services and everything that are offered within the city, trying to pull those out. But there is a process, but not as clear and easy as annexation, which I know our good senator from the 37th is aware of that too in his district where things have happened over there.
Any further comments or questions from the committee?
So these yellow places, to be clear, were not part of the original city.
That is correct.
Did these individuals living in these areas, these property owners, were they able to vote? Or were they excluded from that because of the fact they were not in the geographic outline of the city originally?
Yeah, that is correct. Yeah, they would not have voted in the
Okay.
election, but last May.
What process was followed to allow them to come up and say, we would like to be part of the city of Mulberry?
That I would have to ask the city council. I'll actually be in front of them tonight. But this request has come from the city of Mulberry.
Yeah. I would think there would need to be some type of petition or something from the property owner to be included in the city, and I'd be curious to know that as this bill moves forward.
Oh, yeah, and I'll get that answer tonight and definitely have that for rules or for the floor.
Thank you, and maybe a better map.
Absolutely, we'll have a better map.
Thank you, Mr. Chairman.
Senator Sessler?
Hey, Mr. Chairman, these people, I see this, how many district commissioners are there in Gwinnett County?
There would be four district commissioners and then a chairman at large.
Population of about 1 million?
That's
roughly?
correct.
So these people right now, if they stay in Gwinnett County, they're not part of the city, they would have each elected official, local elected official that affects what happens in their backyard, they have 250,000 people per local elected official in terms of representation.
That is correct. And, as many of these members know, my first term in office or the beginning of the second term, dealing with reapportionment, I did propose expanding the commission, thinking that, as far as local governance, and which I do take the fact that Gwinnett does have a very large staff. They have a great staff that support the commissioners, but I think efficient local governance, when you start talking about districts that have 50,000 plus more people than we do as senators, representing the state, when you get to that local governance level, when you're dealing with zonings, you're dealing with potholes, you're dealing with infrastructure, it's far too many constituents to be able to be, because as you get to more localized government, I think you need to be closer to the people.
So how many elected council members are there in Mulberry?
There would be 5,
5?
including the mayor.
And the city's how big?
The city is roughly about 7,800 residents.
So 8,000 people, so 5 elected.
That would actually be per district, sorry.
I'm sorry, okay,
Yeah.
yeah. So your level of representation is way more representation. If they get in the city, people return their phone calls, it's pretty hard to get a phone call.
Oh, yeah, your city councilman could be your neighbor or could live across the street from you, very accessible.
So to me, this is a representation issue. Thank you for that.
Thank you. Any further comments or questions? Chair?
Thank you, Mr. Chairman. Being a big fan of the motto of the city of Mulberry, at the appropriate time, I would like to make a motion to pass.
Thank you, Senator. This would be the appropriate time. I appreciate that. We got a motion, do pass. We got a second. Any discussion? All in favor, raise your hand. Motion passes unanimously. Thank you very much, and we are adjourned.